it was pretty difficult to gain access to employees and former employees of these companies. They are notoriously secretive, and they feel that it's for good reason, that they're subject to a lot of criticism, and they don't want to perpetuate that criticism, so they become closed off. So I had to do a lot of legwork. I first tried to talk to the outreach and the academic affairs and the public policy shops at the companies, but a lot of them put restrictions on me. In fact, one company said that if we organize a trip for you, you can't use anything that we say, and you can't quote us, and you can't identify us, and you can't even, anything is only on deep background, and we're only going to refer to things in public. Another company said, absolutely not, you can't visit us, you can't talk to us, you can't talk to our employees. So what I did instead is I reached out through various networks to find the people, actually, the people on the ground, the engineers, the lawyers, the privacy professionals. These are the people whose thoughts I really wanted. And I didn't go through the companies for the most part. Like I did it through conferences. I met people at events. I reached out through affinity groups to speak to current and former employees so I could get an honest responses to my questions. So this book is about how companies actually do privacy, what they do behind the veil, behind all the marketing, behind everything that they say they do. This is what people on the ground actually do within the constraints of an organizational system. And it's very easy to say, oh, it's all for show, right? That every hire of a chief privacy officer or every document that they release is just a lie or it's a marketing gimmick. But it's actually much worse than that. So the things that I want people to take away from this is that the systems that companies have created to comply or to do privacy law and design inside their companies are not just marketing gimmicks to make us think that they care about our privacy. They are actually they are designed and created to intentionally undermine our privacy while making us think that they're not undermining our privacy. So it's far more than a marketing gimmick. It's actually much more insidious. The other takeaway is that these systems, these practices that companies engage in are essential to maintaining the informational capitalistic system in which we live. Like it's one thing for us to say that we live in a capitalistic society where information is profit. Well, how does that system maintain itself? One way it maintains itself is with lax public governance. But a company, like an executive, can't perpetuate their company's power without foot soldiers, without people who are in the trenches every day, doing work in a way that amplifies the company's power without even them knowing, right? So the second takeaway is that the systems that these companies have created make it so that even those people that think they're doing good privacy work, that see themselves as privacy advocates, are still part of the system that perpetuates anti-privacy work, that perpetuates surveillance, and that undermines our privacy. And that's how successful, in a way, these companies have been. They've made it so that even people who come to their work saying that, well, my career is defined by protecting people's privacy, because of how their work is situated within an organization, because of the limitations placed on them, and because of these hegemonic discourses, these ideas about what privacy is, are so ingraining that they end up serving the company's surveillance interest in the end. So privacy law has a lot of flaws. And there are a lot of other people that have written about how privacy law, particularly in the United States, is weak, it's self-regulatory, it gives companies too much power. But one of the key flaws with privacy law today, and this applies whether we're talking about the United States, which notoriously has weak privacy laws, or Europe, which a lot of commentators talk about how strong and how revolutionary the General Data Protection Regulation, or the GDPR, really is. Both laws in Europe and lots of the proposals that have been drafted in various states in the United States as well as in the federal government all have the same structure. They guarantee individual rights to data, and they require certain compliance responsibilities of companies for ongoing monitoring. The problem with that is that it shifts the place at which ongoing monitoring and compliance with the law and regulation and governance occurs from the public, like agencies, federal agencies, state agencies who are supposed to act on behalf of the public. And instead, everything happens inside regulated entities themselves, inside companies themselves. So if you write a law that says you have to fill out these documents, you have to write an impact assessment whenever you create a new product, you have to keep records, and you have to do this audit, but you allow the company to hire the auditor, and you allow the audit to be just based on whatever the executive says, or if you keep the records secret so civil society can't access them, or if you allow companies to certify their compliance with a law based on an industry-funded organization that industry members created themselves, then have you really actually created any effective protection for our privacy? So one of the things that this book describes is not just how the system on the ground works to undermine our privacy, but actually how the law is structured in a way that invites and allows companies to create that system in the first place. The GDPR is definitely a step forward, some would say, because it comes from a presumption that privacy is a human right. It tries to keep privacy in the forefront of people's minds. It applies to a lot of companies, and it could result in significant punishments. But one of the things that I talk about in this book is how, at its core, the GDPR is maybe a little bit bigger, but it's more of the same. It's a combination of individual rights, guarantees individuals' rights of access, rights to delete their data, and compliance responsibilities. Both verticals of that are not going to be effective ways of dealing with the problems, the data extractive problems that we have that I describe in the book. Because first, when it comes to individual rights, it's still really hard for one individual to take agency and exercise their individual rights, right? So right now, our system is you have to take an effort to opt out of data collection. You have to make the effort to opt out of cookie tracking, right? So this is just more of the same, of more individual rights that require your own agency in order to solve the problem, which a lot of us don't take. More specifically, privacy harms are group, they're collective, they're global, they're social problems. They're not an individual problem. And what I mean by that is when platforms collect data about us, right, that data about a single individual is wrapped into a system that uses that data, that uses our latent characteristics, uses that information to make conclusions and to manipulate other people who have no way to consent to the collection of your data to manipulate them, right? So privacy is a collective problem in that the system of informational capitalism automatically conscripts us all into a system that manipulates others. Individual rights doesn't affect that, it doesn't change that, it doesn't help that. With respect to compliance, this is much more of what we call a managerialized system, very common in neoliberal governance, that just shifts public regulatory responsibilities into regulated companies themselves, giving them more opportunity to control the narrative, to determine what the law means, and therefore to undermine it through the establishment of these compliance practices that make the law far more, not just a paper tiger, but make it actually work to amplify their own power as opposed to protect consumers.